Great. We'll just jump into the webinar here today. I'm fortunate to have my team with us today. Quite a few attorneys, and your own, and Pooja. I think Pooja was on the webinar. I think she'll join us here. But just quick, as always, we're not giving out legal advice on the webinar today. So it's just informational purposes only, very broad overview. So if you have any specific questions, please feel free to reach out to us to get actual legal advice. And as I mentioned, we've got Anne, a partner with the firm, Yaron, a partner with the firm, and Pooja, an associate with the firm, all helping out today. Really appreciate their help in getting everything ready today. This has been approved for SHRM credit. So if you're looking to get the SHRM MCLE, let us know. Reach out to us. We'll have some information at the end of the slides to reach out and get that taken care of today. For the topics, this topic, when Jackie mentioned it to me about doing the webinar, I was like, I don't know, but every time we write about this or talk about it, the interest from employers is very high. And it's just a good evergreen topic that employers need to get right, and it changes over time as well. So it's important to review this. I think a good practice is at least annually, if not more regularly. Do you have all of this dialed in, and are you performing and following a checklist and giving the employees that are departing the employment all the required information? And how are you handling these terminations as well, terminations and layoffs? So it's a good topic. We get a lot of interest, and we're going to walk through the notices that are required for required notices. We'll walk through those, the optional end of employment documents, and some recommended ones, final pay and accounting, how to document it, the severance agreement considerations, the termination meeting. Hopefully we'll have time. We've got a video that we're going to play. There was a woman that recorded her termination and posted it on TikTok, and just a few lessons from that on how the employer could have done better. They did a lot of things really well, but a few tips that all employers could learn from that. We'll cover that. And then if we have time, we'll quickly touch on deceased employee notices and documents as well. Surprisingly, we get that question quite a bit. If an employee has passed away and the family's contacting the employer, what are the obligations on that? So we'll talk about that as well. So with that said, we'll jump into the required notices. I believe Yaron, you're up on this topic. You're on mute, Yaron.
I guess that would be important. Okay, thank you. All right, I appreciate it. Welcome, everybody. So California, we'll just jump right into it. I know we have a lot to cover today, and the 4 required notices are the most exciting of the whole thing, I'm sure. California requires employers to provide certain documents to employees upon their separation from employment. There are basically 4 forms that California employers are legally required to provide separating employees. So let's just go through them very quickly. The first, notice to an employee as to change in relationship. So the California Unemployment Insurance Code section 1089 requires employers to give written notice to employee as to change in relationship form to all discharged or laid off employees immediately upon termination. No written notice is required if it is a voluntary quit, promotion or demotion, or change in work assignment or location. There are some changes in location require a WARN notice, or if work stopped due to a trade dispute. A sample notice is available online, and I've included the link in this slide. Next, the second is the for your benefit packet. California Employment Development Department requires, or known as the EDD, requires that employers provide their unemployment benefits pamphlet termed for your benefit, or Form DE 2320, to all discharged or laid off employees no later than the effective date of the discharge or layoff. This pamphlet is published by the EDD. The current version is approximately 22 pages long, and it is also available online. We've included that link on the slide as well. Next would be the COBRA and CalCOBRA notices. So Consolidated Omnibus Budget Reconciliation Act, commonly known as COBRA, federal law that allows qualified workers to keep their employer's group health insurance for a limited time after a change in eligibility. CalCOBRA, also known as Cal Mini COBRA, is an expansion of federal COBRA coverage and provides COBRA-like coverage for employees of smaller companies. Which are smaller as 2 to 19 employees. So CalCOBRA applies to employers with 2 to 19 employees, and COBRA applies to employers with 20 or more employees. Employers must notify any covered terminated employees of their CalCOBRA and COBRA healthcare coverage continuation rights. CalCOBRA must be offered to both terminated employees of small employers and terminated employees covered under federal COBRA when their 18 months of COBRA coverage expires. For employers with 20 or more employees, COBRA notice and election form needs to be provided to the employees who are participating in the group's healthcare plan before the termination, and to any of the terminating employees' dependents on the plan. If the termination is due to a layoff or that's under the WARN Act, notice needs to be sent out 60 days prior to termination. These can be rather confusing. The good news is that these notices can be obtained from your health insurance provider, and you can rely on your plan administrator for the necessary notices and election forms. So let's move on to the next one. The health insurance premium payment notice. California Labor Code Section 2807 requires that all employers, including those not covered by COBRA, provide terminating employees with notice of special state programs that pay COBRA premiums under certain circumstances, and that includes this health insurance premium payment notice, also referred to as HIP, or the DHCS 9061 form. This form is a 2-page document. It's available online through the California Department of Healthcare Services website, and we've also included the link to this form in this slide. And just to avoid any confusion, the HIP notice should not be confused with the federal HIPAA law, and it is also not related to either HIPAA or COBRA laws. It is separate and apart.
Great. Thanks, Yaron.
Sure.
Anna and I are going to jump into the optional end of employment documents. So, I mean, that covers it. It's those 4 documents that all employers are required to hand out. I would say all. And so take a look at that. Make sure you have those. Download, get the forms, the COBRA forms from your health provider, and have that packet ready to go. And we do recommend to have that pre-set. So if there's a termination that day it needs to go, you're not looking to download those documents and the wrong document is downloaded or put together. So we like having those arranged and ready to go. So Anne, we'll jump into the optional end of employment documents here.
Yes, there's several optional end of employment documents you can consider providing to the employee, including a termination letter and documenting the reason for the termination. Again, these are not legally required, but it's a good practice. It's really important to document performance as you see it, and do not sugarcoat the reasons for the termination. If the termination was for cause, document that it is for cause. Don't take an easy route out and say the employee was laid off. The company surely does not want to be in a position of initially providing the reason as a layoff, but then litigation is initiated and then they start attempting to explain This is the true and the real reason for the employer's the termination was performance. This is going to appear as if the company is changing the reasons for the termination, and it most likely will impact the company's credibility on why the employee was let go. In any litigation, what the employer says is the reasons for the termination, both in the documents and at the termination meeting, will be key. So, again, don't sugarcoat the reasons and make sure that the stated reasons are complete. Let's move on to this next slide. And I would say that really the best practice in documenting the termination decision itself is to establish a formal protocol for doing that. And then, very importantly, make sure you train your managers to always follow that protocol. The documentation in your file is not something the employee is going to get, and it can take many forms. It can include supervisor's notes, emails, statements from witnesses, pictures. The range of the types of documents is quite extensive. In that documentation, make sure several things are clarified. Is there a company policy that was violated? Is the policy in writing? Did the employee receive a copy of that policy and acknowledge receipt of that policy? You really want to be very specific if a policy was violated, exactly what policy that was. It's also very important to identify key dates of infractions and coaching, as well as identifying the person or persons who were involved in the termination decision. I always highly recommend to clients that before actually terminating the employee, someone needs to carefully review that employee personnel file. See if there's any red flags. Has the employee recently made some complaints? Are there documents in the file reflecting that the complaints were satisfactorily handled? Look at discipline records in the file. Has the employee recently returned from a protected leave of absence? If your file is not complete with all the information surrounding what has occurred with this employee, now is the time to make that complete, add what's needed. And lastly, there's going to be times where you may have high risk terminations and just need second opinions. And that's the time to reach out to legal counsel to avoid any potential wrongful termination or discrimination claims.
Yep. And if I could jump in on that too, we have seen some employers in the past just have a policy say everybody is laid off for any kind of termination reason or anything like that. And it's bad practice to have, as Ann mentioned, if there is cause, you need to be upfront about that for cause, be respectful about it, but you do need to document that for cause, because that's a good reason then why you're letting this employee go. So then if the employee initiates that litigation that Ann mentioned and says, well, you really let me go because of my age, my gender, my protected category, the employer can then have that defense. No, we let you go because you failed to come into work on time 4 times over the last 2 weeks. Here's the dates you were late. We warned you about this. You didn't fix it. That's why we're terminating you. It's a lot more forceful than changing that reason after the fact. So you need to be upfront. And I know it's hard to be upfront and be professional about it, but you need to walk that fine line, not be too aggressive and really embarrass the employee about what the performance issue was, because that might push the employee to go get a lawyer feeling that they need to clear their name. But if you're professional about it, I think the employee will understand it ultimately and come to terms with that. And it's going to help defend any litigation in the long run when you have that documented properly.
Another form a lot of employees like to opt to provide at the termination meeting is the final paycheck acknowledgement. And I think somewhere on one of the slides, we've also got a handout if you want to do that. This acknowledgement can be used in evidence in defending against a claim that all earned wages were not paid. So give the employee, if you use this type of form, give the employee time to review the acknowledgement. If the employee opts not to sign it, then that's their choice. There's really not much you can do about that, but you still have a record of the check itself. And as we'll talk a little bit later, hopefully, you also have a witness present during that separation meeting. I will say that in addition to the check, make sure that you're also providing with that final check a detailed wage statement that indicates the wages, the rate of pay, the hours worked, and all the deductions.
And
We can
a
move.
question just came in too. Is it good to have workers' comp, that there's no workers' comp injury as well on this, like final pay acknowledgement or final acknowledgement with the employee?
That's certainly an option, but there's two thoughts there. Some people will say, you know, the employee will say, well, I felt like I was forced to sign that in order to get my check, and if I didn't sign it, you know, what's going to happen? But yes, that's something that can be done at the final with the final check, and also something to consider including on a weekly or a daily attestation even.
Yeah. Yeah, that's where I think it'd probably be more useful. It can't hurt to have it. You know, it's just another piece of evidence that the employee had an opportunity to complain about workplace issues, complain or file a claim for workers' comp, and they just didn't do it. It's not a silver bullet, but it can't hurt to have it. You can definitely have it.
So I think we're going to move on to the next slide here. This is the one with the example final paycheck acknowledgement. And Anthony, we can move on to that next slide as well. And
Pay and accounting.
yes, I mean, I would, yes, final pay and accounting. Pooja, it's your turn here to cover that.
Hello, good morning, everyone. Thank you, Anne. So now that you know what documents you need for your termination, you should determine what you need in that final paycheck. So what goes in that final paycheck? That needs to include all of their wages, as well as all of their accrued but unused vacation and any other unused pay leave benefits. So remember, you can't have a use it or lose it vacation policy. If the employee has accrued and unused vacation available, they need to be paid out at the time of separation. So you want to be sure you include that. And that form that Anne mentioned earlier, that final paycheck acknowledgement form, does have all of these items listed out to kind of make it easy for you to identify each of these different aspects that are included in the final paycheck. You should also be sure to include any other unused pay benefits, outstanding advances, loans, and offset issues. Now, if you have an employee that either earns commissions or bonuses or is entitled to any expense reimbursement, it is best practice to have them paid out at the time of separation. And in fact, if you can calculate it at that time, you do need to pay it out. However, sometimes with commissions and bonuses, it may not be possible to calculate it at that time. So if that is the case, you should inform the employee when it would be paid. You want to be sure you obtain any required forms, whether it's for to calculate their commission, their bonuses, or their expense reimbursement from the employee. So you have all of the information you need in order to calculate it. So you should let the employee know that the commission, bonuses, or expense reimbursement will be paid at that time. And it is a good practice if you have commissioned employees in that written commission agreement, you have some language that says how the commissions will be paid out in the event of a separation, and that you are following those that policy. Now, tips, a huge part of a lot of our, a lot of your guys' industry here is they are not required to be paid out on the final paycheck. However, credit card tips have to be paid no later than the next regular payday once the customer authorizes that credit card payment. So it is best practice, if you're able to figure out what that tip is, put it in that final paycheck. It's a lot easier than having to try to track the employee down later to make sure they get those tips, make sure they get that payment. So if you're able to run that calculation at that time, it is highly recommended. Include their credit card as well as their cash tips that they are owed up until the time of termination. Now, there are very specific requirements for the timing and the location of the final paycheck depending on the type of employee, the type of separation. So if an employee is terminated, that termination, that final paycheck needs to be provided at the time of termination. So the best practice is when you are terminating that employee, you have those 4 required documents that Yaron mentioned. You have any of those optional documents that you've decided to include, and you have their final paycheck and wage statement. And you want to provide that at the time of termination, at the place of termination. When an employee quits, if the employee quits and gives you at least 72 hours notice and they quit on that day in the notice, then you would provide them that final pay on the last day of work. Sometimes employees quit and don't provide 72 hours notice, or they just stop showing up. They haven't showed up, for 3 days. Your policy says 3 days is considered voluntary abandonment. Then the final paycheck needs to be given within 72 hours. And it's important to remember that 72 hours is not business hours. And so if you're normally, open for business Monday through Friday, the notice comes in on Thursday. That Friday will be their last day. Their final paycheck is due on Sunday. So you want to be sure you're not counting business hours, that it is 72 hours of that notice. Many of employees may be set up to receive their final paycheck by direct deposit. However, even if an employee has authorized direct deposit for their regular paychecks, you need to have specific authorization for direct deposit for their final paycheck. And I believe there will be a sample form as well that is going to be provided that you can have the employee sign, and that would authorize the employee to receive that final paycheck by direct deposit. You want to be sure that they are specifically authorizing that direct deposit. So, in practice, sometimes you're ready to terminate an employee. You want to terminate that employee either today or tomorrow, but for whatever reason, your payroll company, they can't get you that check on time. They're not going to have the wage statement ready for you, but you really, for whatever reason, you need to get that termination taken care of. It is not an excuse or defense for not providing a final paycheck on time just because your payroll company cannot get it for you. In that case, you can get that final paycheck cut from your business account. It does not have to come from your payroll company. However, do not forget that detailed wage statement. Anne mentioned it earlier, mentioning it again because it is very, very important. There are required elements that are legally required to go on those wage statements. However, it doesn't have to look the same as all of your other wage statements. It could be typed up, it could be handwritten, but just be sure you are double checking that all of those required elements, the number of hours they work, their hourly rate, their name, their address, all of that key information is on that wage statement. Even if you get that final paycheck ready using your business account and you don't have that wage statement, you may be looking at a wage statement penalty. So you want to be sure you get that wage statement to the employee along with that final paycheck. And, sometimes you may need to delay the final pay for whatever reason that you can't get it on that day. You need to give it to them the next day. It's not, the best practice, but if that is the only option, you should be sure you're calculating any waiting time penalties. So an employee who does not receive their final wages in a timely manner are entitled to waiting time penalties. What waiting time penalties is a full day of pay for each day that the check is late for up to 30 days. So depending on how late that final pay is, those waiting time penalties can add up.
And Pooja, if I could jump in on that,
Yes.
and that's an option. We've got clients, sometimes the headquarters on the East Coast, they have operations here in California. It's just impossible to get that final paycheck. And so that's what the one option that you can do is go to this, just pay the waiting time penalty of an extra day. If we calculate that, if we know we're not going to get that to the employee 2 days, we pay that penalty, and that's fine to do. It's going to cost obviously more money, but that's one way to cover yourself if you can't process that final paycheck on time.
And Anthony, if I could just weigh in, I would just add when doing that, important that that is notated somewhere, either as a separate line item on that paycheck or somewhere, so later on when doing the math, if in the event there's a dispute or litigation, it's clear that that final paycheck had included already a anticipatory waiting time
I
delay.
agree. It
Yep.
should be another line
Absolutely.
item on the wage statement, probably called waiting time penalty, and,
Yeah.
and add that
Yeah.
on.
Yeah, absolutely. Thank you.
So
And
I'm sorry, I have a question.
yes,
The waiting time penalty, you say a full day pay for each day. As you know, our industry, most people don't work 8-hour days. Is there some calculating to determine what a full day's pay would be for someone who might work 4 days a week, 6 hours a day?
yes. So, it's not their average days that they work. So, for example, if they work 4 days a week, you're not looking at 30 days, looking at four days on average. It is a full, the day that they work. So if they work 6 hours a day, regardless of how many days they work per week, it would be a 6-hour pay for each day that the check is late for up to 30 days. So even if they work 4 days a week and that paycheck is late by 7 days, they're going to get 7 days of pay at that 6 hours a
Okay,
day rate. Yes,
thank you.
yeah, great question. Thank you. So sometimes the employee may request that their final paycheck is mailed to them. And in that situation, you want to obtain their approval in writing. Again, we will have a sample form that you can use. You want to be sure you're confirming their employee address. They may have changed their address and not informed you. And you want to be sure that you are sending that check using some form of tracked mail. So you don't want to just send it regular mail, send it by UPS or certified mail where they have to sign for it, something where you can get that receipt that they've received it. And you want to save that confirmation and tracking information in the employee file in the event that the employee comes back and says, I never received my final paycheck. You have the proof, you have the confirmation, the certified return receipt, the signature, whatever it is from that um, mailing company that you did send it by mail. And when sending a final paycheck by mail, the date of the mailing is considered the date of payment. So even if it does not reach the employee until the next day, it is still the date of the payment. Now, when you're terminating an employee, it is best to just be sure that that they are receiving it at that time. So if you're terminating a remote employee, and I believe this was on one of the slides earlier, you want to be sure that the final paycheck is arriving to them at the time of that termination. So generally, this request for the final paycheck is when an employee decides to stop coming to work or they are quitting. Now, this is something that we see quite often is, well, an employee just kind of up and disappears. They don't come back to pick up their final paycheck. We can't get a hold of them. We've called them, we've texted them, we've sent them letters. No idea where they went. They've kind of just disappeared off the face of the earth. So what do? You have these obligations to provide them their final paycheck. Their paycheck is ready, their documents are ready, their wage statement's ready, but you can't get that employee to show up and pick up their check. They're not giving you authorization to mail their check. So you want to be sure you are document all your efforts. You want to document when you're calling them, save those emails, text messages, copies of the letters, send the letters by certified mail, save the proof of delivery. Track all of that due diligence you're doing to locate the employee. After you have made all reasonable efforts to pay the wage, the California Labor Commissioner has essentially offered to take over for you. So you want to send the final paycheck to the nearest office of the labor commissioner with an explanation of the efforts you made to contact the employee. So they want that explanation, which is why it's important for you to track it, document it, get that information for the labor commissioner to show them, I have tried everything I can to contact this employee. The labor commissioner will then attempt to locate the employee, and if they can't, then it goes to the State of California Unclaimed Wages Fund. And I've included the link here, and that will take you to a web page on the Labor Commissioner's website that will help you locate the nearest office in order to send that paycheck as well as that explanation. And with that explanation, I would include those that proof of delivery, the proof of the letters, your call log, all of that you've done to try to contact the employee. And with that, I will turn it over to document the termination decision.
So I would add to that, remember that accrued unused sick pay is not required to be paid out at termination, but just be mindful if you have a PTO policy that combines paid sick leave with all other vacation and personal days, then that's going to be an exception. So moving quickly on best practices for documentation for all separations, voluntary, involuntary. We highly recommend that you develop an internal checklist. And on this slide, you can see there's, depending on type of benefits, your size of your organization, it can be quite extensive, all of the steps you have to take. So having this checklist will help avoid missing simple items during the termination, and it could reduce liability if litigation ensues. The process of thinking through the steps of a termination is helpful to do when there's no pressure. Time can be taken to ensure that everything is addressed. The checklist is also helpful for organizations to ensure their managers are following all the legal requirements and organizational requirements for every termination or separation. And a point I would also stress here is that once you've made the decision to terminate, act on it promptly. Do not delay. Delays can create changed circumstances and facts that an employee or their attorney can use to challenge and attack the employer's termination decision. So the next slide here, some additional best practices. Keep your pay and time records for at least 4 years. The current law only requires 3 years, but the statute of limitations on some wage claims extends out to 4 years. So the best practice is keep all those records for 4 years, time and payroll records. If you're switching to a new payroll vendor, make sure that before the switch happens, that you have access to all your pay records going back the 4 years. Oftentimes, you lose access once you move on to a different vendor. If you don't have those wage or time records going back for the statutory time period, you're going to be in a very difficult predicament if there is litigation. Also, keep your personnel file for 4 years. The prior law only required 3 years. That has now been changed. Keep those records for a full 4 years following terminations. Document paid sick leave. Keep the records for at least 1 year or longer. Under California's paid sick leave laws, if an employee leaves and is rehired within 1 year, the previously accrued and unused paid sick leaves must be reinstated. So a rehired employee is entitled to the previously accrued and unused paid sick days, in addition to accruing paid sick days upon rehiring. Of course, if litigation is expected, you want to ensure that all your documents and files are maintained, kept safe until the litigation is resolved. And the training aspect also comes into play. Really emphasize with your HR professionals, your supervisors, the need and the importance of documenting performance issues for them to be proactive. And then we can move on to this next slide. And I think, another thing you want to do is to establish a protocol for references and communications about the terminated of employee with others in the company. You want to set this up, have it in place, have it standard. It helps avoid claims of employee saying misrepresentation, defamation, violation of privacy. And oftentimes a policy employers set up is that they will only confirm the title and dates of employment for the employers, and with consent or authorization, possibly the final pay rate. Remind employees, management employees, not to disclose the reasons for the termination to other people outside the company, only those who have a reason to know. A real important, fairly new law creates a presumption of retaliation when an employer takes an adverse action against an employee within 90 days of the employee engaging in protected activity. We are seeing plaintiffs' attorneys raising this presumption in litigation now very frequently. Again, keep that in mind. It all the more important to review that personnel for red flags and make sure that your termination decision is well documented in your personnel file. And I think we're moving along to
Severance agreements,
yes.
optional documents. I believe you were going to speak on this.
I will. Thank you. Severance agreements. All right. So when are severance agreements appropriate in California? So first, let me just say that California law does not require severance pay, despite what some may think. I often get this question, so I'll say it again. There is no legal requirement under California law that employers provide severance pay to an employee upon termination of employment. So you may be asking yourself, if that's the case and it's not required, why offer it? Well, there are a number of reasons why an employer may offer severance. For example, during a layoff, and the employer wants to provide something to the employee for their recognized service, sort of soften the landing. When a company has entered into an employment contract with an executive or otherwise, and that contract provides for severance when certain conditions are met. Another example would be when proceeding with a high-risk termination, and the employer wants to obtain a release and a waiver to avoid future disputes and litigation. That last of those examples is typically the most common that you may experience as to when to have a severance agreement. So if done properly, an employee's execution of a severance agreement would effectively release and waive claims that he or she may have against the employer. And if there's any potential for a dispute about issues that arose during employment, entering into that agreement is an effective way to avoid costly and time-consuming litigation. So what are the common terms in a severance agreement? They'd include, probably most importantly, the general release. And it's a release of all claims that can be released under the law. There's a few exceptions and caveats, but by and large, it would release all claims. There'd also be a Civil Code Section 1542 waiver. That waiver is a release of all unknown claims. So there'd be a confidentiality provision, no admission of liability, non-disparagement provision, which can also set forth what job reference, if any, will be given to any prospective employers, and return of company property. There are others, but those are the highlights and the common terms that you looked for to gain the benefit in exchange for payment of some severance amount. Speaking of payment, so how much is required to pay in severance is a question we sometimes get. And the answer is that there is no magic number or formula. There's no minimum or maximum. Just quite candidly, it's based entirely on the circumstances that give rise to that severance agreement. And that's something that you can talk about and consult with a legal counsel amount for the specific situation. What about time periods? Is there a time period for employees to review the severance agreement? The answer is yes. In California, employees must be given at least 5 business days to review a severance agreement. And typically that's provided to give them an opportunity to review, and if they need to consult with counsel. Severance agreements are multi-page documents typically, and can be overwhelming to an employee. Now, having said that, they can certainly elect to waive that time for review and sign it right away, and often do when the severance check is dangled in front of them at the same time that they're presented with the agreement. But that decision to waive that time can't be forced. If an employee is 40 years of age or older and the agreement includes a waiver of the employee's rights for age discrimination under the Age Discrimination in Employment Act and Older Workers Benefit Protections Act, then they must be given 21 days to review the agreement. Similar to the 5 business days in California, that 21-day period can be waived by the employee if they choose to, but it cannot be forced. Now, even after, and again, still sticking with employees who are 40 years of age and older and waiving age discrimination claims, even after they sign the agreement, they must also be given at least 7 days to change their mind and revoke that signature. That's called typically the revocation period. And while the 21-day consideration period can be waived, the 7-day revocation period cannot be waived. It's important to consider, with that in mind, potentially holding off or not paying that severance payment until after the 7-day revocation period expires. And there's other ways that we can creatively work around that too, in agreements. Oftentimes when the carrot of the severance payment is what's motivating them to sign right away. And so you may want to contemplate, then there are workarounds to contemplate giving the payment and holding back a certain portion that relates to the age discrimination part till after the revocation period. But that gets into the details we don't have enough time for today. So it's highly recommended that employers receive assistance from employment counsel when considering a severance agreement with employees 40 years of age or older.
Great. Thanks, Yaron. Yeah, it does, surprisingly, the severance agreements and the releases are getting complex in California, and the revocation periods, disclosures that need to be made to the employees in those documents. It seems like almost every year we're getting some nuance on that with legislation or case law. So something definitely good to work with counsel, your favorite lawyer, and working that out. So yeah, getting towards the end here, I wanted to spend a few minutes, and I know we're running through a lot of content right here, trying to bring the most value to everybody. So if you've got questions, let us know. Reach out to us afterward. Happy to answer some questions. But I wanted to take a few minutes to walk through the termination meeting and how important this is to prepare for and train your managers and role play with your managers on this termination meeting, and how that's going to play out. It's a critical aspect of having employees leave the company. And if it's not handled right, it could increase the litigation brought against the company. So as an example here that we're going to walk through, we can't watch the full video, but this video I have on the screen is a TikTok video this lady posted earlier this year and went viral. She recorded her termination. She's a remote worker and knew about the termination, heard from her coworkers that they're all being let go. So she got ready, was going to record this, and you could tell she was ready with rebuttals on why she was being terminated and pushing back against the employer. And I think there's a few key lessons here. Yaron and I earlier this year did a video over 30 minutes on this, breaking it down, what the employer could have done better, what they did really well. So if you want a more detailed review of that, check it out on our YouTube channel. But we're just going to walk through a few minutes here today and a few highlights of the video. So let me start the video here and we'll jump into it.
Hey, Brittany.
Hi.
Yes, I'm so sorry. My name's Rosie. I'm just joining the call. Nice to meet you. I'm on the HR team.
Mm-hmm.
Hi, Brittany.
Hi.
Thanks for meeting with me and Rosie. We have an important meeting today. We finished our evaluations of 2023 performance. This is where you have not met Cloudflare expectations for performance. We've decided to part ways with you.
Yeah, I'm gonna stop you right there.
Sure.
So I started August 25th. I've been on a 3-month ramp, and then it was 3 weeks of December, and then a week of Christmas, and then here we are. I have had the highest activity amongst my team. Since I've started, I have had 3 contracts out, done a really great job, man.
So as you can see, the employee's ready to just jump right back in and start putting up these issues about her performance. They were clear, to the employer's credit, cleared, hey, you're being let go for performance. And again, they're walking this fine line of setting out the for cause for the termination, but being respectful about it. And they're letting the employee vent a little bit here, which might be appropriate. And we'll jump in here in a little bit, a couple minutes into it, on when they need to start pushing back to the employee a little bit. But Ann, Yaron, Pooja, any other thoughts right off the start of the video here too? One issue I wanted to bring up too, employees are starting to record these more because they're working at home. California is a 2-consent state. So if this was in California, she would have to get, well, arguably have to get the employer's consent to record this. If the employer's already recording the Zoom meeting, arguably she wouldn't have to get consent to have her own recording then to set this up on the phone. So that's another issue. And in person too, just be prepared for what you're saying to the employee and how this is going down to be recorded and put on the internet. So be knowledgeable of that and be respectful during the whole process.
And Anthony, on that note, I want to add, if the employee is recording and they get your consent, you should also record so you have a copy of it, rather than just the employee having a copy of that recording.
Yep, good point. So I'm going to jump into 2 minutes here into the
anything officially.
meeting.
I hear you.
Also, why are you doing this and not my manager? Not, we've never met, so this seems a little odd that my manager has no idea that this has been happening and the director has no idea that this has been happening. So I'm just definitely confused, and yeah, I would love like an explanation that makes sense.
100%. Real quick, let me carve out the 2 threads. The latter of why I'm on this conversation, I'll put that one to the second half, and Rosie might be better to explain the process of who's giving this information in the prior piece, which is your feedback and notes about your performance. So let me add a little color context to that. So just for clarification, you are not being singled out in this. Your peers are also being collectively assessed on performance. This is a collective calibration for Cloudflare. So I just want to clarify that piece. I won't be able to add any kind of specifics on numbers or...
Wait, yeah, no, can you explain for me why Brittany Peach is getting let go?
So here she keeps pushing back on what the reason, and they've explained it now a few times. If you watch the full video right off the bat, it's performance. And she admits this too. She's like, oh, I've been working for 3 months. I haven't been able to close a deal, but the employer needs to be forceful about that. It's performance. And I'm going to skip ahead here to show another way this comes up, where the employee starts trying to turn the conversation like, you can't give me a valid reason. You're not giving me a reason. It's like, no, Brittany, we gave you a reason. It's performance. We've told you now 3 or 4 times it's performance, and you've recognized this as well. And again, the employer needs to walk that fine line and when to stand up and submit the reason and be strong about that. She is asking why isn't her manager doing this as well? You know, it would have been good to prep that and why somebody else that she hasn't met before is doing this. There might be a good reason, but kind of preview that beforehand. It's a valid reason I think an employee would ask. Does the employer have to answer it? No. But just again, to make the process a little smoother. Yaron, I see it looks like you've got something you wanted to add there.
Yeah, I just wanted to thank you. I just wanted to add real quick that something to remember, especially when you're, when you've got an employee who definitely is ready and is giving pushback, and whether it's defensive or thinks that they've got a very good position, that this is not a negotiation. The decision to terminate has been made. It's important to balance that delicate line and hear them out, but they're not there and you are not there to be convinced to change your mind. So you want to be careful not to get sucked into and taken down that rabbit hole in trying to defend your actions. Once it's been made clear, they don't have to accept it and they can ask questions, but it's not a negotiation.
Yep. And I'm jumping ahead another minute or so here. I want to make this one last point.
Letting that go. If that's the real answer, I would rather just you tell me that instead of making up some bullshit and telling me that right before I lose my job from someone that I've never met before. If you can respect that.
Yeah, I can totally respect that. And I don't think Dom or myself today is going to give you any clarity or answers that's going to meet the expectations that you're communicating to us, Brittany. So I can't speak to.
So am I getting let go for no reason? If you guys can't give me a reason.
That's where the employer needs to push back on performance.
With you separately to give you the data that was calibrated. I'll need to speak with revenue leadership specifically to see if we can get that for you. But
and a little Monday morning quarterbacking there. I don't think that's a good response. She's on the spot, the HR person. I wouldn't get into, hey, we'll get more information to you. Now you're making promises to this employee that's departing your company and you're still going to follow up with them. And if you don't follow up, it's creating these obligations. So again, the employer could have been a little more forceful. It's performance. And the decision's been made, to your own point, and we're moving forward. And I did like the HR representative's response at the beginning, like, we're not going to give you an adequate explanation to your satisfaction right now. We understand you're upset, but this is our decision. We're moving forward. That would have been fine to do that. And I wouldn't start promising additional information. I know we're right up against our time. Any other quick pointers before we wrap this up from Anne, Yaron, or Pooja?
Yeah, I would just reiterate it with this video clip is like, be prepared for that termination meeting. It's unfortunate that both the people present actually didn't even know the employee, but that could happen. Have your talking points and the reasons for the termination already planned out, short and concise. It's not a debate. Stick with your decision, no wavering on that decision, and respect that employee and move the process along. Well, I'd like to give you this notice. Here is your check. Move it along as quickly as you can, and still respect, the employees, what the employee's going through.
And if I can just add, it would be during this meeting too, to the extent that you had contemplated and were prepared to provide a severance agreement or severance package, it would be at this time that is presented to the employee. Again, sometimes it will soften the blow or the response or the reaction. That it's not just that they're being let go, but there is something at the end of that rainbow.